And this is because of the requirement that we have a lot of new methods of investigation. We require a lot of new aspects of technology of investigation. Apart from that, even the criminals are becoming very smart. They have a lot of technological know-how. They have a lot of expertise in handling things, how to crack and how to hack, and several other things. And in terms of organized crimes, especially, we are seeing a lot of development. And because of that, it requires that the laws are to be updated, and the courts as well as the investigators are equipped with sufficient methods of scientific investigation, and with all of the procedures and all that, so that there is no lacuna anywhere, that because of so and so the situation not being available, this procedure not being available, there should not be a lacuna in the investigation causing a hurdle in the criminal justice system. So we have seen several amendments, as I said, in the Evidence Act, CRPC, like Section 45A, 47A, 67A, 53A of the Evidence Act and CRPC. So one of such important law which has been recently passed is the Criminal Procedure Identification Bill 2022. Let us first understand the meaning of identification. Now, the whole concept began from the word identification. Now, initially, the act was the 1920 Act, which is called as the Act of the Identification of Prisoners Act 1920, which was enacted almost 100 years ago. Now, because they saw that the act is very old and it requires a lot of changes, and therefore the new act was required to be enacted, because of which this act has been brought in. For understanding that, we need to understand what is the meaning of identification and why this identification is required. First and foremost, identification means to identify a criminal or a suspected person who is involved in any kind of a act or a similar offense or repetitive offense committed by a same person. So mainly whole idea behind this is to identify the individual or the criminal or suspect who is involved in such kind of an activity. Now, what is the basis for identification, or how do we have to create a database, or how we have to maintain some kind of a information system within ourselves, so that we're able to access this kind of information at all point of time, is the question before us. Now, this identity also is required for the purpose of investigation, because the investigators who are investigating, they would have with certain very minimal data, such as like, there is some samples of hair fallen somewhere, or some fingerprints are available. Whether with that particular information data, will they be able to secure the criminal from the places where he has gone away or he has absconded, is able to trace him, was what the question is. And to also, one important aspect is to establish the previous conviction. Suppose there is a person who's already been convicted, and if he has not disclosed about that conviction and he is being moving around scot-free, then to understand about his conviction also, and to understand his background also, this kind of a identification is required. And lastly, but it is also required for the statistical purposes. In every country, there is a statistics which is maintained about how many crimes have been registered, what have happened to those crimes, whether they've ended in acquittal or conviction, and these kind of data are very important to maintain any kind of a legal system. Then, what are the personal characters of use for identification of criminals? Now, we have different methods of identification, but what are the characteristics which are to be seen is, the first is the blood group, the second is the hair color, third is the voice, fourth is a general appearance, fifth is a shape and size and arrangement of teeth and bones, then comes the fingerprints. So these are the very basic categorization of the characteristics of an individual, which will be specific to an individual, which will not be repeating to others. Like you saw about the blood group, hair color, voice, general appearance, shape, size, and fingerprints. All these 6 aspects will not match from one individual to another individual. So it becomes far more easier for the person to maintain a database, to have these 6 or 7 identity points to be matched, and so that they can streamline and come down to a particular individual while identifying an individual. Then what initially how it began, how this requirement of this prison identification of prisons began, is a thing which we'll have to look at. First, it began in the year 1980 by the 87th report of the Law Commission, which was headed by Justice P.V. Dixit, who had recommended reconsideration of the identification of the Prisoners Act 1920. So that report had emphasized that this Prisoners Act no doubt was there, but it had kind of become obsolete by that time because it was almost a 60-year-old act in 1980. So that the report suggested that they should be it should be seriously gone in through and seen if strong modifications and things have to be looked into. And it's a very comprehensive report which has been made at that point of time. And it emphasized on the importance of fingerprints, especially how the fingerprints play a very important and vital role in identification and how the databases have to be maintained in these things. Then second aspect which was covered in the report was to cover taking up identification data of persons other than the convicts. Now, what originally happened in the 2020 Act, we see the lacuna as such, if you can call it as, is that it would cover the data or the measurements, as we can call the word, which uses measurements. So measurements was only of the convicts and not of the other offenders. So here, when you're talking about convicts, the people who have been imprisoned and convicted by a court and undergoing imprisonment, only those persons were covered. But this report suggested that we have to cover the other persons who are not the convicts also. Then the other suggestion which was there was amendment to Section 4 of the Act, which says that the police have to be empowered to take measurements, which was not available in the Principal Act. Then also one important suggestion which was made was the overlapping of Section 73 of the Evidence Act and Section 5 of 1920 Act, which has to be removed. This is again with regard to the specimen signature and other details, which was found conflicting, and there was judgment to that effect in 1980, which says this particular conflict of Section 73 and Section 5 is creating a hurdle in the rendering of justice, and it will always act as a defense to the accused. And one more important suggestion that was made was to include Section 19 of the Dangerous Drugs Act 1930 under this act to make it. And apart from that, it also finally suggested that since the requirement of the amendments were far too many, it was advisable to enact a separate legislation. This was a report which was rendered in the year 1980 by the 87th report of the Law Commission, headed by Justice P.V. Dixit. Then the point which fell for consideration before the Honorable Supreme Court was in the case of State of UP versus Ram Babu. There's, as I said, just mentioned about this conflict between Section 73 and Section 5 of the Prisoners Act 1920 fell for consideration. And there it is reported in 1980, Volume 2, SCC 343. And while dealing with this act, the Honorable Supreme Court would say that because of this lacunae in Section 5 of the Prisoners Act, which requires the powers of the magistrate to issue orders, they suggested that there should be a suitable legislation on the analogy of Section 5. And therefore, that judgment was also considered as one of the criteria in the report of 1980. Then the second important committee which was formed is in the year 2003. That is the recommendations which were given by the Committee on Reforms of Criminal Justice System. This was the committee headed by Honorable Justice V.S. Malimat, and who took up the issue of reforms on criminal justice system and several aspects, whether it is relating to the appointment of prosecutors, the police personnel, how the facilities and amenities have to be given, the TADA issue, and several aspects were covered, including the functioning of the judiciary, the powers which have to be given to the officers while in investigation. Several recommendations were made because by then the laws which were in place for criminal law especially had become very old and obsolete, because of which the committee felt that it is a requirement that the reforms have to be implemented at the earliest point of time. Then what the report actually said is that the procedural and substantial laws which have been enacted were more than 100 years ago, and therefore there are tremendous changes which have happened, and the investigating agencies especially have to be equipped with modern advanced technologies and forensics, and to so that it is made functional to the present context. Because what was there is all the older laws which were not available or not suitable to our system, and there were several lacunas or loopholes, and apart from that they had become so old and obsolete that that system would not be sufficient to cover up the latest technologies of modern technologies of advanced technologies as well as the modern forensics. So that was the first suggestion that was given. Apart from that, it was also suggested that infrastructural facilities such as accommodation, mobility, connectivity, use of technology to the investigators should be given the top priority. Now, these things why we are referring to is though the report is a very elaborate report which runs to several pages, but we are touching upon only those aspects which are relevant to the current topic in question. So here the challenge was that whether the investigators are given the liberty first and then the platform to conduct the investigation. Are they equipped sufficiently with all the latest technologies and connectivities is what the report said. So there the committee would say that though the investigators have powers which are conferred to under the CRPC or various special statutes which have been given the right to investigate, search and seizure and recording of statements and whatnot. But even then, there were a lot of lacunae in the investigation system, because of which it's suggested that regarding mobility, connectivity, use of technology, there has to be a far more open horizon, and there should be a far more better platform which should be given to top priority. Then even the system of the forensic science and the modern technology, which is being used by the investigators or the specialist agencies like the FSL departments, have also become old, and they have to adapt to the new modern era of technology is also suggested in that. And one important aspect which is also relevant in this scenario is the network of the CFSL and FSL in the country must be strengthened, is what the report mentioned. So what we mentioned by a network of CFS, because there are forensic labs established at various parts of India, and whether these labs are connected and there's a network so that these data are maintained and these data are able to be accessed at various point of time by different investigating agencies, because we have some premier investigating agencies who are investigating throughout India. So this kind of a network is very important, is what the committee suggested. Then also it suggested about having a fingerprint bureau, and also FSL should be equipped with well-trained manpower, because what we saw, in fact, even the situation to even today is difficult for us, because we have been seeing that once a matter is referred for the FSL or it is sent, it actually takes a lot of time for the reports to come back. It takes sometimes few months or sometimes a year also for the reports to come back. And the reason is that they do not have manpower. So when we are talking about FSL examination, it is a very important and very important aspect of any investigation, which has to be done at the earliest point of time. And also the reason that there could be tampering or damage to the source of such data which is available. When we recently saw an issue where the laptop was sent for examination and the data was not recoverable because of some internal issue. And though the hard disk was subjected to certain softwares for retrieving the data, but even that particular retrieving software was not effective, and in fact the data could not be retrieved, which gave a clean check to the accused. So these kind of issues are there which have to be focused upon, and the committee emphasized on having this kind of giving a manpower, well-trained manpower, who could actually take up this kind of FSL examination on a faster pace. Apart from that, the committee also suggested that an Apex Criminal Intelligence Bureau to be set up in national level to collect, collation, and dissemination of criminal intelligence. Now, this is the one of the amendment that you have seen in the new act, that the NCRB has been given the thing that to collect the data and maintain. Now, here it's a question of criminal intelligence that has been spoken in the report. This is in 2003 report, where they say the bureau should be set up at a national level to collect, collate, and disseminate the criminal intelligence. So this was thought about almost about 20 years ago, and that was mentioned, but for some reason it was delayed, and today we have this act. Now, very important recommendation is recommendation number 38, which was given in the said report, which said identification of the Prisoners Act has to be suitably amended to empower magistrates to authorize taking from the accused the fingerprints, footprints, photographs, and blood samples. So this was thought about in the 2003 report, including the samples of DNA, fingerprinting, hair, saliva, semen, and on the lines of Section 27 of the POTA Act 2002. So if we see the POTA Act, Prevention of Terrorism Act 2002, where the police officer has the power who can request the court, that is a chief judicial magistrate, for obtaining samples of the accused persons in terms of handwritings, fingerprints, footprint, photographs, blood, saliva, semen, hair, voice of the accused persons, and who are reasonably suspected to have commission of the offence under this act. So this was, as I said, is a special statute, but the committee recommended that this on this lines the identification of the Prisoners Act has to be amended so that they bring under the purview all these aspects apart, because what the original act, I will just go through that portion also, had only the fingerprint and the footprint. They did not have the photographs, blood samples, DNA, and all these aspects, which are later born in the new amendment, which is now in the discussion. Then the last one of the final recommendations was the recommendation number 149 given by Justice Madhimat Committee, which said that existing intelligence units to be suitably strengthened with specialist and state-of-art facilities. They should develop and share intelligence tools and database which would help investigation and prosecution. So this is one of the things which we have been seeing of late, that this database, maintaining of a database or intelligence tool, which is very important for any kind of a criminal prosecution or a criminal system, which would give a lot of strength and also exposure and ease of investigation and accessibility of information, especially to the investigators. Because most of the prosecutions fail because the databases are not mentioned, because there are no tools, because they don't have access to certain information at all points of time, and they plead that the office investigating officers plead that they did not have either the access to these information, or they have the know-how of how to access this information. Because of which the recommendation was made at number 149 that they should be strengthened with specialized and state-of-art facilities, which was one of the very important recommendations given by the committee. Then let us just run through quickly, before we get into the new act. I would just brush through the provisions of the old act and compare them to the new act. The Identification of Prisoners Act 1920 was in force till last week, and now it is brought that this by the repealing provision of the new act, this act has sought to be repealed. Now, the very important provision here is the Section 2A of the Identification of Prisoners Act 1920, which speaks about measurements. Unlike the new act, the earlier act, the measurements were only two aspects, that is the finger impressions and the footprint impressions. These are the only two provisions which were made under the measurements, which had, as we just suggested, both the committees as well as the other judgments also said that this much of information, the finger impression and the foot impressions, were not always sufficient and not enough for proceeding with the criminal prosecution, and not sufficient for the investigators to shortlist and identify the accused. Then the second aspect was about the Section 3 and Section 4, because now the distinction between the convicted persons and non-convicted persons has no longer there, and it is almost similar in the new act. But earlier the act in 1920 saw two different provisions, Section 3 and Section 4. Section 3 says taking measurements of a convicted person. Every person who is convicted 1 year upwards or has been ordered to give security for good behavior in section 118 CRP, the old CRPC, was supposed to give the measurements. Now, taking of measurements, who can take measurements, at what point that measurements can be taken was also discussed. And section 4 is the taking of measurements of non-convicted persons. A person who is arrested in connection with an offense which is punishable with a rigorous imprisonment for 1 year or more, if so required by the police officer, allow him to take his measurements. So this was the distinction which was given between section 3 and section 4. And also there was a Karnataka amendment to section 96 of the Police Act, which says about the insofar as the non-convicted persons also, there is an amendment by the Karnataka government. Thereafter, section 5, which is also an important provision, which is a very debated provision, which we will see in the further judgments of the Honorable Supreme Court, where if the magistrate is satisfied that there is a requirement of taking such measurements, then the magistrate may order for taking such measurements or the photographs to be taken. So this was the criteria. Now, in the between section 3 and 4, the measurements as well as the photographs, these are different. Only the measurements were ordered to be taken, but the photographs were not permissible. But the new act, there's a substantial difference with regard to what is the meaning of measurement, what all is covered under the measurement, and whether there's a difference between a convicted and a non-convicted or a person who is being arrested. There's a difference or not is the question that we'll have to see. Now, coming to the new act, that is the Criminal Procedure Identification Bill 2022. So as we saw, there was a necessity that these amendments had to be done, and therefore the bill has been passed by the Rajya Sabha on last Wednesday, that's on 6th April 2022, which is now in discussion. And this, as I said, this act has a repealing provision of the Identification of Prisoners Act, which is in 1920. Now, let us just understand the important provisions of the new act. The first very important provision, as I discussed the old act and the new act, is the measurements. Now, the old act, which measurements has only the fingerprints and footprints. Now, as per the recommendations of the previous committees, the measurement has been given a very wide and a very broad meaning, which now has finger impressions, palm print impressions, footprint impressions, photographs, iris and retina scan, physical biological samples and their analysis, behavioral attributes including signatures, handwritings, or any other examination which is referred to in section 53 or 53A of the Code of Criminal Procedure 1973. So which now is a much broader and much elaborate as compared to the old act, because there we had only fingerprints and the footprints, but now we have the photographs of the individual, the iris and the retina scan. Iris is the front portion of the eye and the retina is the back portion, which is taken from a far distance and from a closer distance. Then the physical, the body measurements, then the biological samples which have been taken, including the blood samples and other samples, and the behavioral attributes, how the person has behaved over a point of time. These attributes have to be taken, and the signatures of the individual, handwritings and other examination, which is also provided. So the scope was expanded. It was made much wider so that a lot of details are secured and it is stored, and that give a platform for the investigating agency as well as the bureau to maintain these records, and how best it can be utilized is the principle behind expanding the scope of section 2B of the Act. Now, going to section 3 of the Act, which is says any person who has been convicted of an offence under any law for the time being in force, that is A, then we have ordered to give security for his good behavior or maintaining peace under section 117 CRPC, and is arrested in connection with an offence punishable under any law for the time being in force, or detained under any preventive detention law, if so required, allow his measurements to be taken by the police officer or the prison officer in the manner as prescribed by the central government or state government. So what we just saw is that the section 3 and 4 of the earlier Act came to be merged, and one comprehensive provision has been brought, which is section 3, which has the convicted person and a person who is ordered to be given security Third is arrested in connection with any offense for the time being in force or in detain, who has been detained. So these measurements can be done. Now, there is an exception to the provision which says, provided that any person arrested for the offense committed under any law for the time being in force, except for an offense committed against a woman or a child for any offense punishable with imprisonment for not a period not less than 7 years, may not be obliged for allowing taking of his biological samples under the provisions of this section. So this is the exception which has been given as a proviso, which says that he may not be obliged to allow taking of his biological samples. But as I read the provision, it is not the entire all the measurements. It is only the biological samples which can be refused by him. So we still can have the fingerprints, the palm print impressions, the footprint impressions, the photographs, iris and retina scan, all these things except the biological samples and the analysis. But even behavioral attributes, signatures, handwriting, all can be secured by the concerned either the police officer or the prison officer for recording and storing it. So this is only in case, and that too when it is an offense which is punishable against or committed against a woman or a child, even that exception will not be allowed, and biological samples and have to, must and should be taken from such an individual if the IO so desires. Now, also we saw that was the section 3 which I discussed. Apart from that, we have section 4 also of the Act, which is a very important and drastic change what we can see from the previous Act. Now, that did not provide for any kind of a storing or maintaining of a database, the previous Act. But now, the National Crimes Records Bureau, that is NCRB, as you can call it in short form, has been given the power to collect the data, collect a record of measurements from the state government or the union territory or any other law enforcement agency. It has got now the three parts. One is to collect the data, store and preserve the data, and share and disseminate such records. So this is brought in for the first time by this amendment. So the collection can be done through the state government or the union territory administration from the NCRB, storing, preserving, and destroying the records of measurements at national level. So how it has to be preserved, till what time it has to be preserved, that is also been clarified in the further provisos, and sharing and disseminating such records to any law enforcement agency in such manner as can be prescribed. So now just pausing here for a moment, we just saw these amendments which have been brought in, which are directly relatable to the earlier Law Commission reports, which says that there should be some kind of a system at a national level, which data has to be maintained, which can store, preserve, share, and disseminate. On those lines, this particular provision has been drafted so that there is a national level record which is maintained, and this data can be utilized at a relevant point of times, which can be shared with any law enforcement agency and such manner that is prescribed. So this has a drastic consequence. This has a drastic change in the law, and preserving and collection and sharing of this data has a lot of bearing on how the investigations are conducted, how the records are maintained, how the persons are tracked down henceforth, becomes a very vital aspect, according to me, by Section 4, implementation of Section 4. Then, how this data has to be stored and for how long the data has to be stored also is provided under Section 4.2, which says that the records have to be maintained in the form of either digital or electronic form, and that has to be maintained for a period of 75 years from the date of such collection. And there's a proviso to this thing which says, provided that when any person who has not been previously convicted for an offense under any law, imprisonment for any term, has his measurements taken already and is released without any trial or discharge, or has been acquitted by the court by exhausting all the legal remedies, that such records can be destroyed by the NCRB. Now, for this reason, wherever the person has been acquitted or has been discharged or has been released without a trial, the thing is mentioned that such records have to be destroyed without requiring to 25 years. Now, here is a question where why this data should be maintained and why it should be destroyed at this point of time has also been debated now, which we will see in the further discussion. Then the Other provision which is mentioned under, the subsection 3 is that the state government and the union territory administration may notify the appropriate agency to collect, preserve, and share the measurements in the respective jurisdiction. So there should be a notification to that effect for appointing an agency for such collection and preserving such measurements. And obviously, there is a penal provision which was there in the earlier act also, which provides that any resistance of taking such measurements will become an offence under section 186 for obstructing the public servant of the IPC, and that is there is a jail term and also a fine which is up to 500 rupees or both. Now, the question of taking the permission before the magistrate, whether it's mandatory or not, that fell into consideration in a couple of judgments before the Honorable Supreme Court. And what was discussed in the case of Sonveer versus State, that is in 2018, Volume 8, Supreme SCC, page number 24. What has happened here is the offence was one under 302 and 392 IPC, and the fingerprints were taken by Ayu. The thing was, the defense which was taken, that neither the magistrate's permission was taken at that point of time, or there was any rules which had been framed. So that was taken under the taken up by the accused counsel before the Honorable Supreme Court, where the Honorable Supreme Court would say that neither section 4 mandates taking of such permission before the magistrate, and also that no such mandatory rules have been framed for taking such permission. Therefore, such permission need not be taken. Thereafter, one other judgment of the Honorable Supreme Court, which is Ashish Jain versus Markand Singh, which is reported in 2019, Volume 3, SCC 770, where Honorable Justice Mohan Chandan Gowda has delivered the judgment, where it is a matter relating to offence under 394 and 302 IPC, where the same issue of section 4 and 5 of the Identification of Prisoners Act fell into consideration. Now here, while taking the samples under the order of magistrate, whether it was mandatory or not was also taken as a contention. And what the Honorable Supreme Court would say is it was not mandatory, but it was only directory in nature, and it affirms bona fides and eliminates possibility of fabrication of evidence, and it did desirable to take order, but there is no hard and fast rule that every case should be magisterial order. So what the Honorable Supreme Court would say is that it is as also which was it was held in the 2018 judgment, that it is not mandatory but is directory in nature, but it also gives a bona fides and it gives affirmation that there is no possibility of any fabrication of the evidence. And this was dealt in elaborate by the Honorable Supreme Court, and the judgment was delivered, and there is no hard and fast rule that there should be a such order, was what the Supreme Court rendered in that particular judgment. Then one more judgment, which was in the case of State of MP versus Devendra, which was in the year 2009, which is reported in 2009, Volume 14, SCC, page number 80, where the High Court had given such directions to the government to meet challenge of impersonation. So there were a number of guidelines which were given, and the state of Madhya Pradesh went on to challenge those directions by holding that, by stating that it was very impractical and it can run contrary to the 1920 Act. But the Honorable Supreme Court concurred with the judgment of the Madhya Pradesh High Court, and it said that it confirmed most of the directions, but modifying a few here and there, saying that those kind of directions are required, where the personations have been made by several persons while investigating, which will cause a lot of hampering of the prosecution and also challenging during the investigation. So therefore, the directions were not quashed, but it was upheld by the Honorable Supreme Court. Now, what are the pros and cons of the Act or the new bill, which has now been discussion? That there are several articles, there were several discussions that the new Act has not been properly drafted, or there have been several issues which are very strong and which are against the rights of the individual and also the accused. So these are certain the pros and cons which have been. I've just highlighted a few pros and cons. Now, what the Identification of the Prisoners Act 1920 was there, which had all become very obsolete in terms of the point of the time and well as science, because as we just discussed that we have seen a tremendous growth and development in terms of science and technology. The way the samples are collected, the samplings are sent, and the vessel examinations are conducted, scientific examinations are conducted, the seizures are made. So we have seen a lot of drastic changes in the last 100 years. So what was provided in the 1920 Act was not sufficient, which was not enough, and therefore it was a requirement, and it was the right time for them to repeal the earlier act and the new act to be implemented. Then what was also important is the new technique, having the new techniques and technology to tackle the new generation crimes. Because what we saw is the earlier generation crimes were one without the less use of technology. Like we did not have those computers and the gadgets and the cell phones and the IPs and all that. But now we have seen a lot of new technology crimes which have happened. The use of a cell phone, that they could generate a fake app and transfer monies from one individual to another. They access our bank systems, bank accounts from using the pay apps like Google Pay or phone pay. They access our bank accounts and they draw money. All these kind of things have been happening rampantly. And there are also instances where the masking of the IP addresses has been happening. People sitting from one particular city use the IP address of different other countries and mask the IP addresses and sent out emails of either threat or terrorism or any other emails, which is creating a lot of nuisance to various individuals, and then they're not able to track from where it is being sent out. So to tackle these kind of issues, what is required is we have to be equipped with modern technologies and modern gadgets and modern platform with the IOs, and the investigators have to be given such kind of technologies. They have to be trained and they have to be given this kind of a platform so that they know how the offenders are acting, how the accused are working, and what kind of technology they're using, and how they can be tracked down. So with this new system of having the cybercrime police and the SEN police, now these systems have become much more advanced. They have been given the specialists have been provided. They have been given the technological knowledge, as also they have been given the platform and the techniques, so that they are accessible. They have the knowledge as well as they know how these offenses are committed and how to track these kind of offenders. And then the third important aspect which is required, third important um, requirement for enacting this was to maintain and check the criminal record of an individual. Because what has happened is, apart from having the traditional rowdy sheeter and the history sheeter which was provided on the manuals, there was no specific thing of having a database of all these offenders who are either these databases are not city specific or state specific. Now the database is going to be nation specific, which has to be maintained, so that an offender who commits an offense in Bangalore will tomorrow go to Mumbai and commit a similar offense, because we've seen such instances where they shift the locations after every 5 years or after every 10 years, and they try to venture to new kind of offenses to those kind of cities where they're more susceptible to this kind of fraud and cheating and all these kind of data issues. Then also this is very important to maintain the entry and exit into prisons, because we have to also see that the prisoners' data have been taken, so that when the persons enter or they exit the prisons, they only the inmates of the prisons enter and no other persons enter. And this is a concept which is not only important in India, but it's also been seen from various other countries like Kenya, Hong Kong, and other countries, which have been seeing that the people are trying to gain advantage of the system and trying to exit the jails. There's a lot of jail breaks which have been happening, and allowing them to flee away from the jails. And then when they are trying to be tracked, there is no such record which has been maintained. by the department so that they can track down these persons based on their fingerprints or their retinas or the iris and such kind of scans. So without this kind of a database, we are not being able to track these kind of persons when they're trying to move around somewhere with their details. Suppose this kind of database is maintained and there is a link to the other things like the Aadhaar or any other kind of linkage if it is provided. But right now there is no such provision, but this kind of a linkage is provided. That will make it much more easier, simpler for the investigators or even other law enforcing agencies to maintain this kind of a database and to make best use during the investigations. And in the event of the jail breaks or prison breaks, another issue that India as well as other countries are facing, that these people flee away from the country. And when such database is maintained and these details are provided with the Interpol, the risk of this cross-border movements also is reduced, because either there's people coming into India with this kind of not maintaining a database, or people fleeing away from India. Both these things are maintained when there is there's a jailbreak and the persons who are trying to flee away. And apart from the last, finally, very important thing is to ensure safety and avoid risk of terrorism is another thing which has been seen in this particular act. And as we have seen that the act has provided several positive things, it has also simultaneously there have been complaints that there are several cons, there are several drawbacks of the new legislation. Let us just understand what are the cons that will be complained of. First and foremost, that the bill which has been brought in violates Article 14, 19, and 21 of the Constitution, is the major concern raised by many experts. And they say that because of recording of such data, storing of such data, and accessing this data by the NCRB or any other investigating agency, providing it throughout India, or those agencies which are established in every other state. So there's an infringement of these articles is the major complaint. So this also fell into consideration in one of the reported judgments of the Honorable Supreme Court in the case of Amrit Singh in 2006, volume 12, SCC, page 79, where the appellant, the accused, was convicted of section 302 and 376 IPC, and a death penalty was imposed by Punjab High Court, where section 1 of the Identification of the Prisoners Act 1920 fell for consideration. There, the hair sticks of the accused were found near the dead body, but the accused failed to he refused, in fact, to give the samples to the investigator, and he said that he had the right to refuse and not give the samples. At this point of time, the defense said that he had the right to refuse such giving of samples, and he cannot be treated as a witness against himself. And Article 23 of the Constitution was argued. And then the Honorable Supreme Court would said that yes, obviously he can't be made a witness against himself, but the provisions of the Identification of Prisoners Act of 1920 will not be applicable in the said facts and circumstances, what the Honorable Supreme Court has said, because as we saw that these kind of data were not provided under the 1920 Act, which we saw that these kind of judgments were actually strengthening the fact that it is required that the Act were to be either suitably amended or the new Act has to be brought. Therefore, these judgments were also very important, as well as they threw light upon several grey areas of the old Act, which has had to be revisited and the amendment had to be enacted. Then also the second complaint, or the second issue that is being discussed with the new Act, is that it offers a carte blanche to police officials to collect samples according to the whims and fancies, and there was a danger of serious infringement upon the territory of freedom, individual rights, and civil liberties. This was another thing which was carried, right? Because there is infringement of rights. There was the territory of freedom has been infringed, and individual rights and civil liberties have been. And it is completely a prerogative of police officer to collect the samples. So he would now be with all the powers, and he would act in his whims and fancies. Now we are seeing circumstances where the accused is trying to avoid, is trying to suppress certain things, he's not providing certain information. That's one aspect of the matter. But we have seen similarly several instances where the police have gone beyond jurisdiction. They have acted beyond their jurisdiction and gone ahead and tried to manipulate things, or forcibly taken such kind of samplings or kind of data, which now cannot be curbed or curtailed and cannot be checked. There cannot be a check on this, is what the experts have felt. And that has to be somehow regulated, and that cannot be a free hand which is becoming completely to investigating officers, which will kind of create totally chaos, is what the experts say. The next issue that has been canvassed is the measurements part of it. Now, as we saw, that the measurements, the scope of measurements has been extremely widened, but at the same time, the experts feel it has become very ambiguous and nebulous, and it is not very clear whether this examination of brain mapping and narcoanalysis also will be used and part of biological samples and analysis, because with the word biological samples, it has a very wide meaning or interpretation to it. So if the brain mapping and narcoanalysis is also brought under it, it will have very serious repercussions and far-reaching consequences, which what the experts. And also the experts also have said that what was the intention behind collecting details on behavior attributes is also not understood in the act. What was the reason for having behavioral attributes is one thing which is raised a concern for many. At this point of time, we will also like to understand how is it that the other countries are dealing with these things. Now, if you are looking at the countries like US or UK or even Hong Kong or Kenya or even Bangladesh, these things have already come for discussion, and they have been laws, and there have been judgments of the Honorable Supreme Court, which have not only said that these data like the fingerprints or the retina or the iris and other things, but even the behavioral attributes are equally important. And the system, what the prisons or the jails of those countries have mentioned, is of using of a particular device which is called as a variable transmitting heartbeat biometrics and real-time location data receivers, which have been installed on the prisons to show and understand how the behavioral attributes of individuals are. Now, this will also give a signal to the jailer and the other inmates of the prison that this particular person is acting aggressively, or is getting into that kind of a thing where he's becoming restless or aggressive, and there's something which is to be taken care of, has to be attended. And this kind of situation will have to be taken care. And this is not new to India, but it is already implemented in various other countries. So the government is also on these lines. Now, when these kind of issues were raised, now the response by the government is that it is they have said that it is only in the case of heinous crimes that this kind of data collection is to be done, and there would be clarifications in forms of rules which will be followed in the bill. That's one clarification the government of India has given. Apart from that, it is also the certain amendments which probably will be brought to clarify that the samples will be taken only from the convicts and not from those who are detained. So these kind of amendments and rules will have to be framed, and also clarifying as to who is going to collect the data, whether the permissions are mandatory or directory. All these things will be clarified, and in the forms of amendments, all the rules as and when the things go by, is what the government of India has said. So to summarize, that the old act, which was enacted in way back in 1920, had become very obsolete. It had almost lost its stand, because it had no such kind of a technological or even legal platform to conduct such kind of a technical examination or to correct such data. The new act was required, especially in light of the recommendations which were made in the 1983 Law Commission report, 1980 Law Commission report, and the 2003 Reforms Committee report. And this emphasized that repeatedly, that this kind of situation is required for maintaining the database, collection of the data, And not only, and it also distinguished that it is not only from the convicted persons, but also from the persons who have been detained or been arrested. And because we have seen a lot of other provisions like this Nota and this POTA Act and this the Karnataka Organized Crimes Act and several other enactments, which we are seeing a lot of organized crimes which have been happening, and especially under the provisions of the Karnataka KPID Act and Buds Act and all these provisions, where the accused are taking all different kinds of adopting different kinds of methods to defraud people by making certain applications, by hacking someone's cell phones or their bank accounts or their computer systems, and duping people by impersonating and all these things. So when a person is caught and when this person is accused of an offense, if the database is maintained and they are tracked and these persons attributes are available readily at hand, then it becomes far more easy for an investigator to arrive and to cut short and to streamline and get that particular individual and say, yes, this is the person who is involved and this is the person who we have to have, and produce such data and access such data from the NCRB and other agencies which have been provided. So according to me, the act is not one which has got a lot of negatives, or has got loopholes. At certain places, they require certain amendments or certain rules which have to be implemented so as to clarify, so as to make sure that there is no misuse of powers either by the police officers or by anybody for that matter. As at this point of time, the requirement of law is very essential. The enactment is essential. That has been rightly brought by the government. Those small cons which we have just seen can be addressed by way of some amendments on rules. With that, I like to conclude my speech for today. I'd like to thank all the members and all the participants who are present today to listen to this speech. And I also thank immensely the office bearers of the Karnataka State Bar Council and the team who has organized this particular webinar series, not only this and several other webinar series, which have given us a lot of insight in various laws. And we are always here to learn something. And every day we kind of get some new law. And instead of reading through those books or not being aware of these things, if we sit across and sit and understand, observe these kind of webinars, it gives us a lot of insight on these subjects, and it's a very good platform. So thank you, Baswaraj sir, and thank you, Nitin, for organizing this thing, and thank you everyone for participating.